For those of you joining us for the first time, we welcome you. The Cyber Justice Lab is a research center that explores the interplay between new technologies and the law. We're currently conducting the project Autonomy Through Cyber Justice Technologies and AI, funded by the competition of the Social Sciences and Humanities Research Council of Canada. Our project brings together more than 50 researchers and 45 partners dedicated to the use of technologies and artificial intelligence for the prevention and resolution of conflicts. Over the coming weeks, the Cyber Justice Lab will be hosting a series of online activities that will gather the opinions and experience of legal experts from around the world on the recent events. Ethical issues of the use of AI in times of pandemic, feedback on virtual hearings, privacy in the context of COVID-19, all topics of this rich and varied program. Stay tuned by checking our social networks and visiting our website, cyberjustice.ca. For today's webinar, we welcome Eric Borman, staff lawyer at CLEO, Carl Abrahamson, Access to Justice Service Analysis at CLEO, and Judith Wall, barrister and solicitor at Wall Elder Law. They will present CLEO's new guided pathway for powers of attorney that people can use to make or cancel POAs for property or personal care. CLEO's guided pathway for POAs are interactive tools that take users through a series of online questions, explain in plain language, and then use the answer to automatically create a power of attorney. Along the way, users are given clear legal information about assessing the risk involved, as well as mental capacity issues. The guided pathway are free to use, and they are available as interest in POA surged in response to the COVID-19 pandemic. Many people are now realizing that they need or want POAs, and quickly. So Eric, over to you.
Thank you, Maria. We're here today to show you CLEO's new direct-to-public guided pathways for power of attorney. CLEO, Community Legal Education Ontario, has since 1974 developed clear, accurate, and practical legal rights education and information to help people understand and exercise their legal rights. CLEO's work focuses in particular on providing information to people who face barriers to accessing the justice system, including income, disability, literacy, and language. As a community legal clinic and part of Ontario's legal aid system, we work in partnership with other justice sector organizations and community groups across Ontario. My name's Eric Bornman. I'm a staff lawyer here at CLEO and head of its online interactive projects group, which develops CLEO's guided pathways. And I'm joined today by Judith Wall and Carl Abrahamson. Judith, do you want to introduce yourself?
Yes, I'm a lawyer now practicing as Wall Elder Law in Ontario. I'm a sole practitioner, but I previously was the executive director of the Advocacy Center for the Elderly, which is another legal aid clinic where I worked there for 35 years. And prior to that, I was in private practice.
And I'm Carl Abrahamson. I'm an A2J services analyst at CLEO. I'm part of the online interactive projects team, and I help design and develop the power of attorney interview.
So what are these guided pathways? As of last month, people who need to create or revoke powers of attorney in Ontario can use CLEO's free online tool called Guided Pathways for Power of Attorney. This is an online interactive tool developed in a software called A2J Guided Interviews. Essentially, it is a decision tree. It guides you to answer questions, using your answer to determine the next question. At the end, it outputs the documents you need, as well as legal information tailored to your situation. The software, HEJ Guided Interviews, is used extensively in the justice sector across the United States. And in Ontario, it has been used at community legal clinics for a number of years, but especially here at CLEO for direct-to-public legal tools. Here is how it works. The HEJ Guided Interview presents plain language questions, one at a time. You only see a question if it applies to your situation. Embedded throughout is public legal information, presented just as you may need it to learn more about a question. So if you require help understanding the implications of your answers, the legal information is right there in the question, be it definitions, examples, or instructions. Using logic rules, the HEJ Guided Interviews help organize the user's information to create the output, such as a power of attorney. These logic rules can also verify some types of information for internal consistency and format. Another way the tool helps is by streamlining data entry. Information used on many documents only has to be entered once. And once you're done, it uses your answers to complete all the needed documents at once. So the power of attorney's pathways can complete up to 4 different legal documents as part of the same transaction, depending on the need. We also customize instructions based on your answers. So again, depending on the need, the POA pathways also provide up to 2 sets of plain language instructions tailored to your situation for each type of output. In short, we are using all these features of the HEJ Guided Interview process and CLEO's public legal information to create a direct-to-public tool for reducing the task complexity of creating or revoking powers of attorney. So what are powers of attorney?
So now I'm going to give you some context about what powers of attorney are and how they work. So what really are powers of attorney? Powers of attorney are legal tools that let people choose someone they trust to act as their agent. So my understanding, this is equivalent to the mandate in Quebec. So when they're used, we have 2 types of powers of attorney. We have one for property, which helps both when a person is capable to appoint somebody to help them manage their money, and then also if they're incapable to take over management of their property. And for personal care includes health care, but also decisions about other facets of your life that are non-money. So things like where you live, food you eat, risk you take, so safety issues. For this pathways, we were we were helping people to prepare and revoke powers of attorney, so they can make powers of attorney of either type. So you have to be 18 or over to make a power of attorney for property, 16 or over to make a power of attorney for personal care. You have to be mentally capable. You have to do this voluntarily and not being required to do this as a part of a service. And there are we made sure that we met all the formal requirements for powers of attorney. There's no mandated form in Ontario. And then to revoke powers of attorney, you can make a new power of attorney of any type and it revokes the previous one automatically. But we've also included in the pathways a formal revocation form, as well as letters to contact your bank or wherever your assets are, because powers of attorney remain into effect for the third party until they receive notice that the power of attorney has been revoked. We've also included in the pathways alternatives to powers of attorney of either type. And that was important to include so that people would know if they needed a power of attorney or what they could do instead of doing a power of attorney, but also to know that if their power of attorney failed for some reason, so for example, if their attorney died before them, they still are covered. There's alternatives in the law, so that they're not left without a substitute decision maker. And this was particularly important to point out for healthcare, because in Ontario we do have an automatic healthcare decision maker if you have not created a power of attorney. It's just within the law. So we wanted to explain that to people for their own benefit. So during this period of COVID, powers of attorney have become much more important to people. People may become ill, they may need help temporarily, or they may lose capacity during the period they are ill with COVID. And so preparation of the powers of attorney was a fast way to help people get somebody to have formal authority to ask questions and advocate for them. So the Ontario government did pass an emergency amendment to the power of attorney legislation, so to permit lawyers and paralegals to get signatures of grantors and witnesses via audio video conferencing, providing one of the witnesses is either a lawyer or paralegal. And lawyers and paralegals are both licensed in Ontario. The Law Society of Ontario also provided us with practice guidance for this process and warnings about how to do it well.
Thanks, Judith. CLEO's guided pathway for powers of attorney is now accessible to the public from the Steps to Justice website on the COVID-19 resource page, which is that red bar you see at the top of the screenshot. Steps to Justice is a site that provides people with accessible and reliable legal information to properly exercise their legal rights. Led by CLEO, it is a collaborative project of leading justice sector organizations, including the courts, government, and the legal profession. From the COVID page, you can access the Power of Attorney Pathways Start page, which also has information such as what you need to complete the pathway. The link for that page is stepstojustice.ca/guided-pathways/POA. Or you can find it by browsing all of our guided pathways at stepstojustice.ca/guided-pathways/home. An important feature, the pathways let you save your information to our secure system, which is hosted in a public sector data center run by Legal Aid Ontario. So, from Steps to Justice, you are first prompted to log in or create an account. But you can also use the pathway anonymously. However, anonymous users are unable to save information on the system. Work must be saved locally. But users can create an account that allows them to save partially completed pathways, save their documents, or come back and complete additional pathways later. Either way, the user agrees to terms of use before using the tool. And then the guided pathway begins. And I'm going to turn it over to Carl to tell you about the Powers of Attorney guided pathway.
Hi, yeah, so I'm gonna take you through a quick demonstration of how the pathway works. We're gonna take the scenic route through the pathway, so we won't see every single question, but we'll see some of the most interesting and substantial parts. So the pathway starts with a series of information explaining what it does, explaining how the technology works, and allowing users to see if this pathway is not for them. For example, because they don't meet the age requirements, because they live outside of Ontario, given that this interview produces a power of attorney that's specific to Ontario law, or if they have a complicated situation where it's important for them to seek in-person legal help. So throughout the interview, as Eric mentioned earlier, we use a number of tools in order to present more plain language legal information. One of them is the Learn Mores. So you'll see out on the side, there's a box with the title Alternatives to Appointing an Attorney Who Lives Outside of Canada. If the user clicks on the Learn More button, then they get a pop-up box which explains in plain legal or in plain language terms what alternatives they can have if they don't have a trusted person who lives in Canada to appoint as their attorney. There's a number of different types of Learn Mores. Some of them give more information about a legal process or concept. Some of them give more information about why you might want to make a decision or why you might not want to make a decision. And some of them just tell you more about how the interview works in a specific place. We also use pop-ups. So the interview has gone through a rigorous plain language editing process, but there's some places where we can't avoid using a legal term. In those cases, the term is highlighted in blue, as you can see here with the term attorney. If the user clicks on it, they get a plain language explanation of what the term means. So we're now going to skip ahead a little bit to the point where the user selects which document they want to create. In this interview, the user can create a power of attorney for property, they can create a power of attorney for personal care, or they can create both a power of attorney for property and a power of attorney for personal care. They can also choose to create a revocation, which is a document that cancels any previous powers of attorney they have. If you choose both a power of attorney for personal care and property, the interview first takes you through the normal sequence through a power of attorney for personal care, and then it takes you through a modified version of the sequence for power of attorney for property, which basically allows you to skip entering any information that you might have entered your first time through, for example, your name and your address. So this is the sequence that I'm going to take you through now. So we're going to skip over the part where you just enter your name and your address and go straight to the part where you select your attorney. So the attorney information section starts with this slide, which details the type of questions that we're going to ask you and the type of information that you're going to need to answer them. Most of the sections begin with this kind of slide in order to give users the opportunity to find any documents they might need or bring up any information. The section also starts with a number of slides prompting users to think about the kind of concerns or questions that a lawyer might also ask them to think about when making a power of attorney. So for example, in this case, we ask users to think about whether the attorneys have in mind, understand their personality, their values, and their beliefs, and whether they'll be willing to act when the time comes. And you can see that these slides are also path specific. So this is what you see when you're doing a power of attorney for personal care. If you were doing a power of attorney for property, you would get the same type of sequence, but with different questions. In this interview, the user can choose to appoint between 1 and 3 attorneys. We'll do 3 on this run through. First, they'll be asked to enter the name of the attorney. Then if they're filling out a power of attorney for personal care, they'll be asked whether the attorney they have in mind is compensated for providing them a number of services. Now, if they answer yes, they'll also in the Learn More will explain why this is important. If they answer yes, we then ask a follow-up question asking whether that person is their spouse, partner, or relative. Now, the reason for all this is that there's some complicated series of criteria for when a specific person can't be your attorney, but rather than just presenting that criteria up front and having to ask the user to figure it out themselves, we can guide the user through each step of that criteria and only ask the user questions that are relevant for them. So suppose the user answers no to this question. Oh, and we also have a Learn More here, reminding the user what counts as a spouse in this case. You might think that it's obvious whether you're married to someone or not, but in the healthcare law, that's not always the case. So if the user answers no here, they're directed to a new slide, and now we think that their attorney is probably ineligible. So in this case, we give the user 2 options. Either they can choose somebody to appoint the ineligible attorney, or they can choose to discard that information and continue with their other attorneys. Similarly, if the user enters the information of an attorney who doesn't live in Ontario, we show them a slide that tells them that an attorney who lives far away might not be able to respond in time when there's an emergency and might be a risk if the user needs to an attorney to make a decision where a delay in making that decision could harm their health outcomes. And again, we give the users multiple options for how to respond. They can either replace that attorney, they can appoint an additional attorney who does live in Ontario, who can act in time, or they can choose to just continue with this attorney. Once the user has appointed all their attorneys, we give them more information about the specific powers of an attorney for personal care and the things that they're expected to do. And the user can click on each area to learn more about those types of decisions. For example, they can click on healthcare to learn more about what a healthcare decision involves. We have a similar pop-up for the duties of an attorney for personal care. And here you can also click on each duty for more information. For example, here you see a plain language explanation of what it means to act in good faith. As you have probably seen by now, there's a lot of information in this interview. There's actually about 35,000 words that Judith diligently wrote for us. But instead of kind of throwing this small novel at the user, the learn mores and the pop-ups and the pathway allow us to structure it in a way where the user only needs to see the information that's relevant for their case and allows them to be well informed about the legal realities of their power of attorney and their situation. So once you're done entering the information of all your attorneys and seeing this information about the powers and the duties, we ask you to confirm your attorneys once again. This also allows users who had to discard some ineligible attorneys to review what they end up with and to decide to restart the process if they're not happy with it. So if we click yes, then we get to choose whether our attorneys make decisions jointly or jointly and separately. Here we'll choose jointly and separately. Because we made this decision, the interview now gives us a slide that tells us more about some of the specific consequences of that decision. And again, if we click on jointly and separately here, we'll get a plain language explanation of the term. These pop-ups don't just appear the first time the term appears, they appear every single time we use the term throughout the interview. So if you forget what something means, you can always click on it to get a reminder. Okay, the next section that the user goes to now is the witness section. So in order for your power of attorney to be valid, you need witnesses, and this interview allows you to, the user to enter information about the witnesses, and then we pre-fill those parts of the document, and the witnesses just need to sign. So the section starts with a slide that details who's eligible to be a witness and who's not. And in the Learn More, there's information about options that the user has if they can't read or if they can't sign the document, for example, because they have a physical disability. We've designed this interview with the idea in mind that some users might not be completing the interview themselves, but might be using the help of a trusted intermediary. That could be a family friend, it could be a social worker, it could be a librarian, but somebody who's helping them create a power of attorney using this interview. We currently also have a slide in the witness section on virtual witnessing, which is a special option for witnessing that was approved because of COVID-19, which Eric already mentioned and Judith will talk more about later. But the beauty of this HJ author technology that we use to create this is that we can quickly create new questions in order to respond to changing legal realities like this. The user then enters the personal information of the first witness and the second witness. Now, if you were just doing a power of attorney for personal care, you'd be done at this point and it would generate your documents. Because we're doing both a power of attorney for personal care and a power of attorney for property, we now have to go through the section for property. But because we already did the one for personal care, the interview asked us whether we just want to use the same attorneys. And in the Learn More, there's information about why you might want to use the same attorneys and why you might not want to use the same attorneys. If you select yes, that you do want to use the same attorneys, we again give you information about the duties of an attorney for property. And again, you can click on each duty to get more of a plain language explanation of it. We then ask you to confirm again whether you really do want these people to be your attorneys for property as well. If you selected no here, then you would go through the attorney selection process again, but with attorneys for property. If you select yes, you'll instead go straight to the restriction section. So restrictions are special clauses that you can put in your power of attorney for property in order to customize it, to limit your attorney's authority in some way, or to give them special directions to do something. In this interview, we've added a number of restrictions that the user can add using this checklist menu. So the user can add as many restrictions as they want. In the Learn More, there's information about how this works, and the user can click on each of the restrictions in order to get more information in plain language about how that restriction works. We also have behind the scenes logic rules that make sure that the user doesn't enter contradictory restrictions. So for example, we don't want the user to both say, you have to continue giving charitable gifts and you can't give any charitable gifts. So we have logic rules that make sure that the user doesn't end up with an incoherent power of attorney. Now, suppose the user selects the divorce and separation restriction. This is a restriction that if one of the user's attorneys is their spouse and they divorce or separate from that spouse loses their ability to be the user's attorney. If the user selects that, they're then directed to a page that gives the user the full text that will be part of their power of attorney, so the user knows exactly what they're adding. And the Learn More provides a plain language explanation of exactly what this clause does. If the user selects yes again, they're then asked to select which of their attorneys is their spouse, so that name can be entered into the text of the clause. Again, the user here doesn't need to enter a new name. The interview simply remembers which names it's already entered and presents those as options. Okay, we'll skip ahead to the next section. So just a tiny bit of legal background, and hopefully Judith will correct me here if I get anything wrong. So if you create a springing power of attorney, that's a power of attorney that for property that takes effect only when you become mentally incapable of managing property, somebody has to assess whether you're no longer mentally capable or not. In a normal case, if you don't write anything specific about it in your power of attorney for property, that's a formal capacity assessor. But you can choose to have it be a custom capacity assessor. That can either be a specific person you choose, or it could be a type of person, like a nurse or a psychiatrist. In this interview, we explain that option, and then we allow the user to enter a custom capacity assessor. If they choose yes, we ask the user whether that is a specific person, so like my Dr. John Johnson, or whether it's a type of person, so like a nurse. If they select a type of person, we then give them a checklist menu of the most common different types. If they select a specific person, we then have them enter the information of that person. Next, you're guided to the witness section, but because the interview knows that you've already entered one witness or two witnesses previously, we give a checklist menu where you can either choose to use the same witnesses as before, or you can choose to enter new witnesses. And that's the end of the interview. Now, before you actually get the outputs, we walk the user through certain next steps in order to make the power of attorney official. So it's important to us that the interview not just be involved with actually creating the documents itself, but also with the practical steps that go beyond this, signing them, witnessing, making sure to give it to the people involved, and these kind of other practical steps. There's also here more information about virtual witnessing, and there's information about the exact documents involved. And finally, how to cancel your power of attorney. So if you no longer want it to be effective. And then your documents are produced. So immediately you're taken to a landing page where you can download all of your documents. So here we can see the power of attorney for personal care generated. We can see the 3 different attorneys and their names. We can see the decision we made about how attorneys were to make decisions together. And we can see a number of other things. The witness information is already added down here. We will also get 2 instructions. So one of these instructions are instructions for using your power of attorney. These are directed at the user. They give them information about how to sign a power of attorney, how to add witnesses, and a number of other practical things, who to tell about it, where to store it, and things like that. Then we also have instructions for being an attorney. These are instructions that we thought the user would give to the attorney in order to introduce them to their new role, They tell them about what kind of decisions they'll have to make, what kind of things to take into account when making the decisions, and what kind of duties they have. Both of these instructions are dynamic, so their exact content will change based on the choices that the user made throughout the interview and what kind of things are in their power of attorney. And if we had made a revocation instead, we would also get 3 documents: an instruction for how to use the revocation, again, how to sign it, how to witness it, who to give it to, the actual revocation document, which needs to be signed and witnessed, and a sample letter the user can use to send to a bank or a financial institution, informing them in proper legal language that the power of attorney has been revoked. And now I'll pass it over to Judith Wall again to explain some more about the concerns we had in developing these power of attorneys.
So first, I'm going to explain a bit more about the changes to the law and practice directions that we had. So the Emergency Management Procedures Act is a piece of legislation in Ontario, which is being used by the Ontario government to amend all kinds of pieces of legislation. So they did amend the P of A legislation to permit this virtual witnessing. And as I mentioned before, this works if one of the witnesses is a licensee of the Law Society of Ontario. So it has to be a lawyer or paralegal that's licensed. And to perform the virtual witnessing, the people complete at their different sites, wherever they are, complete identical copies of the power of attorney. So the grantor has one copy, they sign it, and then they hold up their signature to the camera so that the 2 witnesses can see them. And then the 2 witnesses in sequence then also sign their own copies, so they're separate copies of the power of attorney, also showing to the camera their signature. Then the 3 copies of the power of attorney must be joined together. So the 3 copies together are considered to be the valid power of attorney. And so that's very important. The person has to know to get all this material together in one spot. And the copies of the powers of attorney are considered identical, even if there's minor non-substantive differences in format. So it's very common. Like, I downloaded this presentation on my iPad and it messed up some of the formatting. So that's not significant in terms of the validity of the power of attorney. Okay, Eric, I'm going to need your help. I can't move it again. Sorry. So third-party acceptance of the powers of attorney, the third parties who are going to rely on the power of attorneys may still reject the power of attorney that's signed and witnessed in this way. The law doesn't require them to accept it. So they may insist on what I'm referring to as wet signatures, which is executing the power of attorney in the presence of each other. So as a result, even though we have this authority as lawyers and paralegals, many lawyers and paralegals are still doing this in person, and they do it on the doorsteps, passing back and forth the same document, or in their backyards to keep the social distancing. But it is a possibility, particularly if people at a distance, they can still do this at a distance using the procedures. The affidavits of execution of witnesses to the power of attorney are not required for the validity of the power of attorney, but many lawyers, so like I always did those affidavits of execution when I did powers of attorney for clients, and so many lawyers prepare these affidavits, and so lawyers and paralegals may also do virtual commissioning. But they did not change our law relating to the commissioning. And so it's only a permissive practice directed from the Law Society that we can do this, along with warnings about risks related to virtual commissioning. So when we were preparing the pathways, CLEO asked me to think about the common questions that I always get about powers of attorney. So I've had extensive legal experience in this as directly giving, assisting clients, but also I have actually done hundreds of presentations on powers of attorney because of the nature of my practice. And I also worked on law reform initiatives related to powers of attorney, sitting on many government committees when they were changing legislation. So what I tried to think about was all the different types of questions that I got in all those different settings from different perspectives. And one of the things I really notice is people ask the same question, but in different ways. So I tried to incorporate that into the text as well, so that however people think about this issue, they can get their answers. So here's some more of the questions. These deal a lot more with the risks, and also questions that are very personal to individual, like, can my attorney for personal care direct a doctor not to give me care or to stop treatment that I had consented to? So people are concerned of how their attorneys would work, and they wanted to know what are the risks of preparing each type of power of attorney. And also in the type of practice I had, I did thousands of cases that dealt with abuse of power of attorney. So this was near and dear to my heart, and I wanted to make sure that information was getting into the pathway. So some of the issues that needed to be addressed. So I'm coming to this very much as a practitioner, but I've also had a lot of experience doing plain language. So we wanted to obviously do plain language materials, but some legal terms really needed to be included, even if they're not plain language. So we had to figure out which ones had to be included and which ones not. Some terms just can't be made more simple if it's going to have be accepted by third parties. So we try to limit that, but it was really at that task of sorting that out. We also needed to determine the information that needed to be included in the pathways to ensure that people understood what they were preparing, understood what they were going to sign, that they know the risks and benefits, and they know the alternatives, both so that they could decide whether or not they needed to do a power of attorney, or whether if the power of attorney failed for some reason, they would have a fallback. We also tried to address the common misunderstandings about powers of attorney that are held by users, even lawyers, and the formal systems. So, common example, banks always want their own power of attorney form used and not powers of attorney prepared by lawyers. They shouldn't be doing that because they can get their own lawyers to check the power of attorney prepared through this program or through a lawyer. But we needed to tell people this, that when the bank came to them and said, no, you can't use this because you have to use our form, they would know what to do at that point. We also were concerned about creating a power of attorney that would be valid and accepted by third parties. So if you saw, when you saw what Carl put up, the documents look like any other kind of documents that I would have prepared in my own office. And we also warned people that third parties could reject the power of attorney produced, and then what to do about that. We give them sort of practical hints. Next slide. So other issues, we had to determine the necessary information to determine if the valid powers of attorney could be misused and abused, and then what could happen, what the person can do when this happens. So we're alerting people up front. We also wanted to make sure that the power of attorney produced by the pathways is acceptable to the legal community. So this is both for reputation and credibility, so that lawyers would say, yes, this is a good power of attorney, even if they didn't draft it themselves, but it's drafted through this program. And then we also wanted to limit the risks that the power of attorney produced could be used to cheat or defraud the grantor, abuse the grantor by misuse of authority, by warning people about all the different types of authority the person has, which is something that is often misunderstood. And quite bluntly, I wanted to make sure that CLEO or myself would not be held liable for providing advice via the pathway. So we're giving all the detailed legal information, but that is correct, and giving people warnings throughout, so that it's the person taking on the power of attorney, their risk, but we were minimizing that to the greatest degree. We also organized the order of the text to respond to common questions and variants of those questions. And the variants, it's very important. It's just how people think differently about the same issue. So that was my experience based on the live, particularly live presentations, to include that in. And then we really wanted to address the common misunderstandings about powers of attorney, because there are so many. I can go on the internet, and even websites produced by lawyers in Ontario often have errors about powers of attorney. And we wanted to tell people about what would happen if they executed it in the wrong way and in the correct way, and also explaining ways of resolving their problems. So that this way they didn't have to necessarily go out to seek a lawyer if the bank rejected the power of attorney. To ensure that when people are customizing the power of attorney, we gave them stock clause options rather than letting them draft their own clauses. And this was done deliberately to avoid clauses being inserted that wouldn't be legal or that wouldn't be understood by third parties. We explained the legal terminology that should not be changed in order for the third parties to accept the documents and also to be subject to challenge. I went through all the different case law on powers of attorney to make sure that I was picking up any cases where the terminology was challenged. This also gives credibility to the documents if you have some of the legal terminology. We included warnings throughout the pathway about the potential for abuse and misuse, so that this way they make good choices. And then lastly, we included information sheets for attorneys on their duties and responsibilities. And this is a practice that many lawyers do already. And so we thought it would be a good thing to put it into the pathways so that the person who's going to actually be responsible for the power of attorney understands their roles, including their limitations. Because again, my experience has been that attorneys often take over too much power when they don't have it. So this way we made it clear in the duties and responsibilities sheets.
Thank you, Judith. Powers of attorney is the newest of CLEO's direct-to-public guided pathways, which are available on Steps to Justice. It was a major undertaking, and it was funded generously by Canada's Department of Justice. CLEO also has other guided pathways for family law court forms. We also have pathways for tenants with rental housing problems. And over the next year, we have plans to release guided pathways for a simple will, work visa, and permanent residency applications in a citizenship and immigration context, assisted living in Ontario, such as long-term care homes, as well as additional family law court forms and tools for tenants. At CLEO, we think that direct-to-public automated legal tools show great promise for delivering legal information and assistance to the people who need it most. But we also believe that the approach to these tools matters a great deal. And so we seek to build tools that are easy to use, serve a diversity of users, are secure for personal information, and are sustainable. Our content is interactive, practical, clear, and accurate, and we target intermediaries, recognizing that many people may not be able to access these digital tools, but may have a trusted service provider who can act as an intermediary with the technology. The privacy protections and security of the system are appropriate for safeguarding sensitive personal information. And the development and maintenance of our legal content and information technology systems is cost-effective and built around institutional support. And we are committed to evaluation. but how do we measure or evaluate whether we are reaching our goals? How do we get at impact? This is the question that is the impetus for research CLEO is now undertaking right here with the Cyber Justice Laboratory and McGill University as part of sub-project 8 of the ACT Autonomy Through Cyber Justice Technology Research Partnership with additional funding from the Law Foundation of Ontario. Our approach, in a sense, we at CLEO are using online interactive technology to reduce the complexity of form completion and thereby lessening the public's reliance on experts. Complex or vague terms are being replaced with plain language questions, instructions, or links to public legal information. We aim to write simple questions that interactively follow what we hope is an intuitively ordered decision tree. The questions are embedded with this information, presented just in time. We use logic to do arithmetic, make other calculations, generating the necessary outputs based on the answers provided by the user. And we reduce the number of sources of information that an individual must locate and look at by embedding or linking to external sources of information where necessary. And these efforts to reduce complexity represent, though we didn't always think of it in these terms, a functional literacy approach. We couple this with outreach and partnerships to reach our intended audiences, and we use A2J guided interviews because of the institutional support that allows us to maximize the proportion of our resources that go to content over information technology with respect to this work. So our research is looking at how to best evaluate this approach. And while we're interested in user statistics and survey responses, which are useful and helpful information, we know that these don't tell the whole story. For instance, what's the context? Who is the tool for and what is its role? And this is especially true with respect to the issue of screening. And both Judith and Carl talked a lot about the warnings and other information, the alternatives to powers of attorney that Judith referenced at the beginning of the presentation, which are presented at key decision points throughout the interview. An outcome to using this system could be a decision not to create a power of attorney or to go see a lawyer because there's some complexity that's beyond the intended scope of the guided pathway. Efficacy, as opposed to user satisfaction or pure administrative efficiency. What are the quality of the outputs? What is the quality of the guided pathway as an educational tool? And there's an interesting anecdote that was shared by a colleague in the United States, and their organization had created both a video and a flowchart on family law court process, the same topic, and they had conducted a user study group. They broke the participants into two groups. One was shown the video, the other was given the flowchart. At the end, both groups were given a quiz and a survey. So the survey responses indicated that the folks that watched the video were very happy, quite satisfied with the video format. The folks that received the flowchart were less satisfied. However, on the quiz, the people that had the flowchart did much better than the people that had the video. How do we evaluate for that type of variance? And then impact. More broadly, what is the impact of our work? To capture the bigger picture, we've started with a framework proposed in the United States by the Florida Justice Technology Center. And the framework embodied three promising characteristics. One, it's an attempt at a holistic approach to evaluating the use of this technology. It recognizes the inherent complexity of these tools, if not impossibility of measuring certain actions taken and outcomes, and the iterative and interconnected quality of both. But finally, it strives, nevertheless, to achieve or arrive at a mechanism for making educated guesses to fill in those gaps, to say just because it's hard or impossible to measure, what was the impact or outcome of a user's experience, doesn't mean we shouldn't try and incorporate this into the model. And at the core of this is a particularly challenging question. What does a good outcome look like, and according to whom? And the folks in Florida prepared a non-exclusive list of the different types of outcomes, which I think captures the inherent challenge of this particular question. So the goal of our research is now to propose a model of evaluation and then to use the model to animate CLEO's evaluation of the guided pathways, including the powers of attorney pathway. And the character of the pathways presents some interesting possibilities for metrics, especially whereas in Ontario there's a good relationship with the courts and profession. In particular, where users create accounts and save data, there is the promise of many readily collectible metrics, not just basic metrics such as page views, sessions, or satisfaction survey results, stats that are baked into the system and collectible on an ongoing basis, but also with appropriate user consent, we could check back in later, track the user journey through the process on and off the system, assess outputs for quality, and collect feedback from institutions, courts, and the private bar, people who've seen what has happened next. So this is our starting point. The research with Cyber Justice and McGill is in its early stages, but we look forward to reporting back on our progress as the evolution of the guided pathways, such as for powers of attorney as a direct to public legal tool, mature over the coming years. So with that, I want to thank you all for tuning in today, and thank Judith and Carl for your presentation. And Maria, I'll hand it back to you.
Thank you, Eric. Yes, thank you for this presentation. I see we have a couple of questions in the Q&A panel, so please do not hesitate to send in any more questions. I'll go ahead with saying that this webinar is recorded. So for those who wish to see the webinar again, it will be made available on our website at the end of today. Also, we had a question from Hannes, who asked if you were surprised by any aspect of how the users interact with the tools.
Hello, Hannes. It's early days. We don't have a lot of information yet. We released the pathway in April, and we're still in the process of digesting early feedback from the public. We do have some feedback, so people have been using it, but we don't have anything to report just yet.
Thank you. Also, we had a question. If a person has a Quebec mandate for health and property and an Ontario POA for health and property also, and they were created at the same time, which one of will the Ontario courts tend to apply if they govern different properties and finances in Ontario? I don't know if that's a question you can answer.
I actually can try and answer. It depends on whether the Quebec legislation and the law includes the provisions that Ontario has where there's conflict of laws. So like, I'll give an example from our legislation. Our legislation states that if you have a valid power of attorney, and it could be the mandate, because that's the form in Quebec, if it was done in proper form in Quebec, and it could be used in Ontario. It's nice to say this in the legislation. So if the Quebec legislation is similar, we could use the Ontario one in Quebec. But from a practical point of view, people don't accept it. So what happens is that in Ontario, they would be very reluctant to look at the mandate. They'd say, oh, well, we don't know how to use this. And then you'd end up going to a lawyer to get the proof of validity. And I've done that when I was in private practice. So it's actually good to have, if you're living in different jurisdictions, have different formats that fit the jurisdictions. for us, that the lawyers who from the other jurisdictions would need to include that the power of attorney they want to have multiple powers of attorney, so that this doesn't automatically revoke the previous power of attorney. Because if you made one in Quebec, it probably would revoke the one in Ontario. Now, I'm not 100% sure of that, but unless you say it, put it in each other, then I think they could be valid. But it's a practical problem.
I see. Thank you, Judith. We also have a follow-up question from Hannes. What do you think is the main way people discovered this pathway? Was it through your social networks, on the website? How was it promoted, we can say?
So again, it's early days. With our family law guided pathways, a major point of entry to the pathway system is the Ministry of Attorney General here in Ontario that posted links to the family law guided pathways. And we didn't really have time to get into it, but we're beginning an outreach campaign where we are speaking to frontline service providers. So promising sources of referral that we envision include possibly the Ministry of Attorney General here in Ontario, but certainly social workers and nurses. And perhaps, Judith, maybe you might comment from your experiences to the types of frontline service providers who experience power of attorneys as a client need. And I should say as well that with all our guided pathways, the content is integrated with CLEO's Steps to Justice website, and Steps to Justice has created a COVID-19 research page, and in the present circumstance, there's been a tremendous amount of traffic that has visited that site, and so the power of attorney pathway is presented there.
I had a lot of experience, particularly with social workers who would be helping people do powers of attorney. And I also taught for 5 years at the Faculty of Social Work in the Masters of Social Work program at the University of Toronto. And I would tell social workers, you should not be playing lawyer when you're doing this. However, many times they're sort of forced into helping their clients, or to put it in a more positive way, they want to help their clients to do the powers of attorney. So this tool, I think, will help them a great deal, because now this tool has all the correct law in it, because that was often missing from the social work assisted powers of attorney. They didn't know enough of the law to do it properly. So the social worker could help the person doing this power of attorney using the program, and it could be a valid power of attorney. I also see this pathway as a terrific education for those social workers, and also nurses. Sometimes nurses get into this place where they're helping people do powers of attorney, that if they can do this on their own and learn a great deal about powers of attorney, so that if they're helping a client or giving some client advice about whether you should make one or whether there's an alternative, they've then got the accurate legal information close at hand. So it's an education to them as well, even if they're not preparing it for themselves. They're using it just as a teaching tool.
Thank you, Judith. There's also one question: if the guided pathway for powers of attorney is available in French?
It will be soon. We have translated, we're over halfway there. We've translated all the English content into French, and we're in the process of creating the pathway itself. There are a few more I's to be dotted and T's to be crossed, and I unfortunately don't have a clear time frame, but we'd like to do it later this year.
Perfect. Also, I've seen there's quite a few people asking if they could have the slides after this presentation. As I said, this webinar is recorded, so you should be able to see it again. However, I'll leave it up to our panelists today to decide if the slide could be made available later on.
Thanks, Maria.
A question from Amanda. What if the person does not have anyone to act as a witness for she or he? Is there a designated service outlet where he or she someone can hire a witness, similar to getting a witness for a passport application?
As far as I know, there's no designated service that does that. But because I would actually recommend people then go to their local community legal clinic, because our legal clinics are right across the entire province. We have 72 clinics now. I can't remember the exact number, but they're quite accessible. So the clinic may be able to assist them in that witnessing process. And then also for the virtual witnessing, all the clinics are staffed by lawyers and paralegals. So if you have to do the virtual witnessing, you have that there as well.
Thank you. Sudbury Community Legal Clinic asked, will the recording be available on our website or CLEO? It will be made available on our website. Again, I'll leave it for Eric and to decide if it will be made available on CLEO's website. However, if you do not see it on our website, do not hesitate to send me an email and I will share the link with you. And I think we've covered all questions. I don't know if I've left any in the Q&A panel. Oh, there is a question. I don't know if you can answer today. Was it the Federal Department of Justice that provided funding support for this guided pathway? Wendy is asking on behalf of the Legal Information Society of Nova Scotia, as they are working on a similar POA pathway, but that is challenging without the funding.
Department of Justice is one of CLEO's funders. So there wasn't a specific application put in for this tool.
Perfect. Thank you. So I think now we've covered all questions. There's a comment about the fact that the Google form is not for today's activity. I will be sending the right Google form link, and I will stay online so you can copy paste this link on your browser so you'll have enough time to fill out the form. I want to thank our panelists for accepting our invitation and taking the time to tell us more about their new innovative tool that I think is really essential in times of crisis like the one we're going through. Also, I would like to thank our audience for participating in today's webinar. For tomorrow, we'll have Associate Lawyer Marie-Claude Sarrazin, who will give a lecture on technology-based procedures and remote administration of oath. You can register on our website, cyberjustice.ca. Again, thank you, Eric, Judith, Carl, and stay safe, everyone.